I'm joined now by the Attorney General of California, Rob Bonta. Thanks so much for joining me.
My pleasure. Thanks for having me, Brian.
So, we've got some breaking news now within the last 24 hours here. A new temporary restraining order. Can you explain what just happened in court?
Absolutely. California, along with Oregon and Portland, went into court uh, over the weekend on shortened time, seeking an emergency order preventing uh, the deployment of California National Guard to Oregon. And just 24 hours earlier, on Saturday, the same judge in the District of Oregon, federal judge Immergut, had granted a restraining order saying that the Oregon National Guard could not be federalized and deployed to Portland because there was no factual basis for it. It violated the sovereign rights of the state of Oregon, threatened public safety, and for other reasons. And having received that order, the federal government, being told that the Oregon National Guard cannot be deployed to Oregon, in their wisdom, decided that they should deploy the California National Guard to Oregon, although the judge had just said that the facts on the ground did not justify National Guard being deployed. So I listened to the entire hearing last night. The judge was miffed and perplexed, to say the least, about the regarding the administration's position here. Told the lawyers for the federal government that they are officers of the court and explain why the deployment of California National Guard does not violate her order from 24 hours earlier. And she ruled from the bench. She ruled in our favor, granted the restraining order, and because the federal government had brought in the California National Guard after being told they can't federalize the Oregon National Guard. And because we pointed out that in just minutes before the hearing, the existence of a memo from Secretary Hegseth federalizing the Texas National Guard, 2,000 of them, and ordering 400 of them to go to Portland and Chicago, we asked for a broad order. And we said it appears that the federal government is pursuing this whack-a-mole approach. If they're told they can't bring in the Oregon National Guard, they'll try to bring in the California National Guard. If you tell them tonight that they can't bring in the California National Guard, it appears they'll try to bring in the Texas National Guard. And if you tell them they can't bring in the Texas National Guard, who knows what is lined up next to bring in. So we asked for an order preventing any National Guard from any state and the District of Columbia from being deployed to Oregon. The judge granted that appropriately broad order, and was very strong in her treatment of the federal government. Just 24 hours earlier, she had said this is a nation of constitutional law, not martial law, and that the president's determination that the National Guard was appropriate was untethered from the facts. And so I think that really says it all. Trump is not a king. He's not above the law. He cannot treat the National Guard as his royal guard to deploy and to do his bidding when he wants, where he wants, for whatever reason he wants. And we took a strong position and we blocked him twice in 24 hours.
Does it look like within the last 12, 24 hours, the Trump administration is complying with this order?
From what we can tell, yes. So far, who knows what is going to happen next. We think that there are National Guard from Texas and maybe other places on the way to Chicago. The judge's order from the District of Oregon only applies to Oregon. So Chicago, Illinois, has brought a case already trying to prevent the National Guard from being brought into Illinois. But so far, we don't have any reports that any California National Guard are in Portland exercising any official duties in contravention of the court order. If we do, we would take immediate steps to enforce the order, perhaps move towards contempt. This judge is not happy with the way the federal administration has treated her first order, and I don't think that she would take too kindly to any violations of her order. But so far, all we're aware of is compliance. We'll keep our ear to the ground. But we are moving towards a preliminary injunction hearing on October 29th. The temporary restraining order, which we secured, is for 14 days. And then we'll have a full trial on the merits combined with the preliminary injunction hearing on October 29th and hopefully get a permanent order preventing the National Guard from being federalized and deployed to Oregon.
When we see Trump engage in these bad faith efforts to try and, figure out some justification to get these troops deployed, and we'll talk about that in just a moment, but does each subsequent case get more difficult? Like when a judge sees that Trump has no justification to do it in California and then has no justification to do it in Portland and gets blocked as he has in California, as he has in Portland, and then tries to do it in Chicago, does each subsequent case make it more difficult because a judge sees, to your point, that he's just doing whack-a-mole here, and he says, okay, I might not be able to do it in Portland, but then I'll just find some other city to be the target of my ire. Are judges wising up to what he's doing here?
I think so. I don't see how they can't be. The District of Oregon federal judge, Judge Immergut, cited to Judge Breyer's order in California, clearly showing awareness of what he contemplated and how he analyzed the case and what he ruled on. And I think, judges are watching, of course,
Right.
what's happening. This is unprecedented stuff. And in this case in particular, to have a National Guard from a state where the governor does not want them deployed and to federalize them, so that's California, and to deploy them to another state where that governor doesn't want them deployed either.
Yeah.
That's never happened. We've seen federalization of a National Guard within a state be deployed. We've seen red states have their National Guard deployed into blue states, but we've never seen this combination of both a blue state that doesn't want the National Guard deployed and another blue state having that National Guard deployed into their state happen before. So, it seems like there's always an additional escalation that's dangerous, something unprecedented that's happening. And Judge Immergut very appropriately suggested and stated in the very opening of her order on Saturday, on the first temporary restraining order, which was granted, that this is an issue about the relationship between the federal government and states and state sovereignty. It's about the relationship between the military and civilian law enforcement and about the relationship between the judicial branch and the executive branch. And all of those very important bedrock constitutional principles are at play here. So this is high stakes stuff. And I'm sure judges are very aware of what's happening around the country and will have that context and that knowledge if a case comes to them specifically.
Something striking that happened over the weekend was that Trump came forward and tried to convey this bogus idea that there is an insurrection happening in Portland. And I thought that word was interesting because I feel like he's trying to make his legal argument in the court of public opinion and try to manifest this idea into reality that there is some insurrection or rebellion happening. And the reason that word caught my attention is because there are one of three thresholds that need to be met in order to justify military deployment domestically, and that is that there is a foreign invasion, that there is some rebellion or insurrection, or finally that there is a failure of a local government to be able to effectuate federal law. And obviously none of those things are happening. The judge that you cited in Portland, Immergut, said that him using any of these justifications, I believe he said rebellion or insurrection, that him using this justification was untethered to reality. But can you talk about him trying to manifest into reality any of these three planks, given that needs to be the basis, the pretext that he needs to be able to send these troops into any of these cities?
Sure. He's always trying to state that there is an emergency because when there's an emergency, the executive branch can secure additional authority and additional power. He wants that power. He wants that additional authority. And so he, as a figment of his imagination and not backed by the actual facts on the ground, he consistently states that there are invasions, emergencies, rebellions, the inability of the government to execute the federal law with the regular forces, all the things that would trigger more authority for the executive branch if true, but they're just not true. And the Judge Immergut, very compellingly pointed this out as the federal government attorneys in her court pointed to social media posts, to Truth Social posts from the president as their basis for the facts on the ground in Portland. And she said that is not what is the determination of the facts. The facts are what the actual facts are on the ground. And there is no rebellion. There is no invasion. There is no inability to execute the law with irregular forces. And so, thus, there's no emergency powers. But Trump and Miller and Hegseth, they consistently try to talk past the judges to the court of public opinion, making their case, but not backed by facts. And it's irresponsible and inappropriate. And it is very appropriate that courts continue to be a place where if you're going to take a position, you need to bring the receipts, show the facts, show the proof, demonstrate that the facts on the ground are what you say in your Truth Social post. If you can't, and he couldn't, then you don't get the power that you seek. And so we went in with facts, we went in with the law, we prevailed, and according to the judge's order, it wasn't even close. But you are right that there's an ongoing attempt, and we will see more of it, of the Trump administration to try to convince and honestly not be honest with the American people that there's some sort of emergency when there's really not.
Can you speak for a moment about a letter that your office sent to the Ninth Circuit Court of Appeals at the end of September, so just a few days ago, about this idea that the Trump administration, that by virtue of paying Trump some deference in this Los Angeles case, knowing that there was the thinnest of all pretexts to be able to do so, that would actually invite him to abuse that deference even further in a place like Portland, which of course has indeed materialized.
Absolutely. We're seeing Trump giving an inch and taking a mile. And when offered some deference by the court, completely abusing it. And we had flagged this original June 7th order out of that deployed troops to California as one that that had no temporal or geographic limits, and that it didn't say just LA, it didn't say just California, it didn't just say just in June. It was broad, and we noticed that then, and we worried about it then, and then we wanted to reflag it for the court in a couple of days ago because what we had feared came to pass. Trump used this deployment of troops in LA, literally 1,000 miles away from Portland, to deploy troops to Portland. And that is exactly the abuse of power that we feared, that Trump believed he had carte blanche to deploy National Guard anywhere around the country at any time. And it makes absolutely no sense that a early June set of circumstances in LA could lead to the deployment of troops in Portland, 1,000 miles away, 90 days later. It just makes no sense. But that's the broad, abusive, and unlawful reading that Trump is giving this order. And I'm glad that Judge Immergut saw through that and blocked them twice over the weekend.
And so do you think that mentioning that to the Ninth Circuit Court, as you've done, and saying, hey, look what happens when you give him an inch, he'll take a mile, he will abuse whatever deference you pay him. Do you think that whereas the Ninth Circuit may have been willing previously, as far as the LA case is concerned, may have been willing to offer him, that deference, and look, they stayed Judge Breyer's order, so maybe there was a likelihood, as far as they were concerned, that Judge Breyer's order wasn't going to stand. Do you think that this changes the calculus now for the Ninth Circuit to see, look what us giving Trump a little bit of leeway is manifesting in real life here. It's giving him carte blanche in his mind to go and send troops into other cities completely untethered to reality. And maybe now, as we continue to consider this case, we should reconsider the facts as they're actually playing out.
I think that the Ninth Circuit will be very carefully policing the bounds of the deference and making sure that only appropriate deference is given, that it's not unlimited deference, that it's not absolute deference, that there are times, and I think Portland is that time, and I think, frankly, LA is that time as well, and we'll see how we do on appeal. I think we will prevail when that deference is, a bridge too far, or many bridges too far, when it's way beyond the deference owed. There is a legal modicum or sum of deference that is owed, but it is not absolute. And Trump has tried to turn, the legal deference that he is owed, which has limits, into unlimited absolute deference to do anything he wants, whenever he wants.
Right. And if even judges who he himself appointed are able to call that out, then I think it's as clear as day what he's trying to do. With that said, we'll leave it there. California Attorney General Rob Bonta, thank you so much for the time. I appreciate it.
Thanks, Brian. Great to see you again.